On January 18, 1994, independent counsel Lawrence Walsh delivered his final report on the Iran-Contra affair, thus concluding his 7-year investigation. In it, he assailed President Bush for pardoning Caspar Weinberger and 5 others on Christmas Eve, 1992. He also said there was insufficient evidence to prosecute Presidents Bush and Reagan.
I have a very brief statement, and then I'll take whatever questions you may have. Today, the panel of senior judges who appoint independent counsel made public the final report on the Iran-Contra criminal investigations and prosecutions. This report is likely to be the last official word on Iran-Contra. It was publicly exposed 7 years ago, and the activities prompted my appointment in December of 1986. At that time, the public trust in government had been badly shaken as a result of the revelations that the Reagan administration had been secretly selling arms to Iran, that it had been secretly supporting the Contra military effort in Nicaragua, and that there had been an intermingling of those two operations in the diversion of Iran arms sales proceeds to the Contras. Much is now known about these matters and how they evolved and who was responsible. This final report fully describes our findings and prosecutorial decisions. Unlike earlier reports by the Tower Commission and the Congressional Iran-Contra committees, our report focuses on the criminal dimension of the affair. Those earlier investigations were obstructed by lies and other means. Our report therefore adds some new facts to the historic record. The application of the criminal law to Iran-Contra was a time-consuming, expensive, and often imperfect process. Yet it is difficult to see how corners might have been cut. The mandate given to me by the appointing court was very broad, the broadest the court has ever granted. The investigation involved individuals in the White House, the CIA, and the State and Defense Department, as well as the National Security Council and even the Department of Justice. It required a review of hundreds of thousands of documents. Some of the most significant were withheld until very late. The activities occurred in more than a dozen countries and were cloaked in secrecy. Even after the operations were exposed, claims of national security thwarted complete prosecutorial scrutiny. Finally, congressional grants of immunity made some prosecutions unwieldy and resulted in overturned convictions for Oliver North and John Poindexter. Despite these obstacles, indictments were returned, cases were brought to court, convictions were obtained, and the investigation proceeded. The final report describes the 14 cases in which criminal charges were brought, as well as the investigations of 17 other individuals. The law required that I set forth fully and completely a description of my work, including the disposition of all cases brought and the reasons for not prosecuting any matter within my jurisdiction. To fulfill this requirement, it was necessary to lay out all of the facts, to fully explain my decisions to prosecute or to decline prosecution. The report explains the most significant facts we uncovered, who was criminally responsible, and why the investigation and prosecutions proceeded as they did. The purpose was to give the court, and now the public, a full accounting of our work. I believe that the mandate given to me in December of 1986 has been fulfilled, and that the Office of Independent Counsel did everything it reasonably could to see that the rule of law was administered fairly The final report will now allow others to decide whether the job was done correctly. Yes, sir.
Taking into account your frustrations, do you feel that justice was done?
I think it was what Justice Holmes said about justice once. Justice and the application of the law are not always concurrent. The justice was done to the extent that the law, reasonably applied, could achieve it. Justice is a difficult concept to deal with and to ever satisfy fully. But in terms of the prosecutions that were able to be carried through the maze and thicket of the criminal procedures and the information that accompanied it, I believe that justice was done to the extent that it could be reasonably done.
Well, if I could follow up on that,
Sure.
Do you think that a number of those involved got off easy?
I think in terms of sentences imposed on other people, it may seem that way. But I think it's also important to realize that the courts, in imposing sentence, were dealing with persons who had invested in enormous amounts in public service and in service to the country. They were giving up the full value of that investment when they were convicted or pleaded guilty. And I think the courts took that into account. I think also the sentencing courts may have been inhibited by immunity granted in some of the cases. They were not anxious to challenge the appellate court any more than they had to. But those were two factors, I think.
You think that Presidents Reagan and Bush still have a lot to answer for with this?
I think President Bush will always have to answer for his pardons. I think that was the most unjustifiable act. There was no public purpose served by that. The others who tried to serve President Reagan's policy thought they were serving the public, but President Bush can never justify the pardons as an act of public service. President Reagan, on the other hand, was carrying out policies that he strongly believed in. He may have been willful, but he at least thought he was serving the country in what he did. And the fact that he disregarded certain laws and statutes in the course of it was not because of any possibly self-centered purpose.
How do you think it will affect their respective places in history, given the mixed findings about the two presidents?
I didn't.
How do you think it will affect their respective places in history, given the mixed findings about the two presidents?
There's an echo, and I'm not sure. How do I think it will affect whose place in history?
Bush and Reagan's.
Oh, Bush's and Reagan's. I just don't know. The public, the American public, is very perceptive, and it forms its own evaluations. And the areas of conduct that are described in this report and that we have focused on are simply one part of a very large field of activity. And because one type of activity may be subject to criticism, there were other areas of activity that may be subject to praise. And the American public will, with great intelligence, take all that into account.
Judge Walsh, do you think...
Okay.
At one part of the report, you say that you concluded that no criminal charges should be brought against President Reagan, Vice President Bush, Edwin Meese, or Donald Regan because the belated production of notes and other documents had delayed your investigation beyond the point where it could be effective. But at a couple of other points you say, the fundamental reason for lack of prosecutorial effort was that there was just no evidence beyond a reasonable doubt against those gentlemen. Is there any inconsistency there?
No, I think I'm not sure exactly of the language we're talking, but I think the arguments are cumulative. If there is in the areas where we say there is no basis for a prosecution, then we add to it the questions of delay. In some areas there were possibilities, not necessarily as to those individuals you mentioned, but there would have been possibilities of prosecution if we'd had the information earlier. But that wasn't the problem, as I remembered, as to President Reagan. President Reagan, we concluded that there was no evidence that justified a criminal consideration.
Judge Walsh, how do you, sir, respond to the criticism that this gives those mentioned no due process? It gives them no day in court.
It is a very disturbing position for a prosecutor to be in, and it was also a very disturbing position for the court to be put in. And I'm glad you raise it and give me an opportunity to explain exactly what is required by the statute. At the time the statute creating the independent counsel was passed, the Senate was concerned that in an earlier investigation the prosecutors had made a rather condensed report and had then written books. And the Senate wanted, it's in the legislative history in the Senate side, that's why I speak of the Senate. But Congress wanted independent counsel to be required to report fully. If he had anything to say, let him say it in a report which was to be submitted to the court which appointed him. And they also were concerned that the public and the courts might think that independent prosecutors had, in a sense, whitewashed a case, that they had not fully exercised their powers. And so it has a dual requirement. Not only that a prosecutor must explain why he prosecuted someone, even more difficult, he must explain why he did not prosecute someone if it could be argued that that person was within the jurisdiction given him by the court. Now, in most cases, this is simple, because all previous independent counsel I can think of under the statute were dealing with a single individual. So you either indicted him or you didn't indict him. But my mandate was so broad. There are a large number of people who were embraced within it. And I didn't, as the report discloses, I didn't attempt to take up the case of everybody arguably within it. I just took those as who had been perhaps the most active in it. Now, the second thing that I think we must bear in mind is that I was reporting to the court just the same as a private lawyer would report to his board of directors or the board of directors of his client. It was my job to, under the statute, and if you look at the legislative history which is enclosed in the first part of volume 3, under the statute it is to report in detail why I didn't prosecute. And it was my judgment that this required me to report to the court in very unvarnished terms. And it would then be a second question for that court to decide whether it should be made public. In other words, the report I wrote was for the court that appointed me. Whether that was to be made public was a decision for the court that reviewed it. And that court took great pains to protect those mentioned. It gave them 4 months to respond to what was said about them. They were all furnished with the parts of the report that spoke of them, and they were given an opportunity to write whatever they wished in response to it. And you will notice that the volume of responses is longer than the report itself, and that some of them are quite lengthy. But I think it's important to realize that the report in the first instance was intended for the court. And in my judgment, it would have been wrong for me to sugarcoat the report or curtail it just to enhance the chance of publication, and I did not. I wrote it exactly as I saw it. Okay. Yes, sir.
What are your reflections on your own role, your own work on this report, this whole long process? How do you feel about your own role? Do you have any kind of self-criticism, wish you had done certain things sooner, or perhaps if you had had more time, more of a budget, the result might have been different, there might have been more indictments? Or
you know, I think it's a very proper question, and it's one that I have tortured myself with from time to time. I think the first, there were some mistakes of judgment that I don't think they affected the ultimate outcome, but they may have made it take a little longer than it otherwise would. I underestimated the job when I took it. I thought I could handle it with 10 lawyers. In the Watergate investigation, Archie Cox was much wiser. He had a bigger staff. He subdivided into teams very early. I came more slowly to that realization. My decision to expand was goaded by the fact that the Congress was threatening to grant immunity, and so that I realized that although I might like to work at a more leisurely pace, I wasn't going to have that choice. The second question was whether I should have attempted to asked the grand jury for an indictment of North and Poindexter limited to the obstruction charges before immunity was granted. We had an obstruction case earlier. It wasn't, and that would have left out any charge of the diversion and perhaps the underlying conspiracy. The reason we couldn't move quickly on the diversion was that we could not get the Swiss records. Switzerland is very protective of its banking records. And although those records were requested in December of 1986, they weren't produced until November of 1987, long after the congressional hearings had terminated. So unless I wanted to proceed on hearsay, which would have been very risky in a case like this, I wanted to see those records myself before we proceeded. So the question would be whether to fragment the cases or to prosecute solely on a fragment, because if, you know, once one of those indictments was returned, that was going to absorb enormous parts of the energy of the investigation. Both of these gentlemen were very well represented, and once an indictment's out there, the investigation's course has changed permanently. It gets into a mode of leading to trial, defending post-indictment motions, and there was a serious danger of it derailing the investigation for that period. It also would have projected me in a head-on conflict with Congress. I don't know what would have happened. Whether Congress would have persisted in attempting to compel the testimony of these two persons, whether they would have respected a grant of immunity under those circumstances, whether a court would have compelled them to accept immunity under those circumstances. Whatever would happen would be a three-way controversy between Congress and us and the defendants. And the control of it would shift to the courts and away from the investigation and myself. So that under all these circumstances, we took the other course of trying to protect our investigation from the immunized testimony. And we went to great lengths to do it. And as far as our own organization was concerned, we were successful. Even the appellate courts that reversed the convictions found that we had indeed avoided taint of the investigative and prosecutorial team. The trouble was that with the widespread publicity that accompanied this testimony, it was impossible to isolate witnesses from it. And that in the end, even though Judge Gazelle and we attempted to meet that problem by instructing every witness not to supply us with any information they didn't know themselves before the immunized testimony, the appellate court felt that was not a sufficient safeguard. So those are the two areas. Now the third point where we had to make a major decision was after the conviction of Poindexter. At that point, the operational conspiracy, we sort of have divided our work into sort of two areas. When the operational conspiracy of Poindexter, North, McFarland, Secord, and Hakeem, and the supervisory and assisting groups who withheld information as to their contribution. So at the end of Poindexter, we had completed the work on the operational conspiracy. Secord had been convicted, Hakeem had been convicted, McFarland had pleaded guilty, North had been convicted at that point, and now Poindexter. And so a strong argument could be made that's a good time to quit. You're ahead. But it seemed to us that we couldn't say our job was done until we tried to get the testimony of Poindexter and North, however unwilling, and we couldn't do that until they had been convicted. We couldn't do it while they were awaiting trial. There's no way to force that. So that's what we did, and that proved a very laborious process. North, in particular, engaged in extensive litigation to prevent our doing that. And that all of this drags out time. Time is always hurting. It always hurts the prosecution under any circumstances. But where you have a temporary office and you're holding together people who aren't here permanently, they're all taking time out from what they plan to do for their professional activities. And we're running at great expense because GSA couldn't find us space like this that didn't cost very much. We ended up paying expensive rent, not only for ourselves, but we had to rent an equally, almost equally large office for the defense so we could make a skiff out of it, so they could have classified information. So we were unable to curtail our expense, and we are at the mercy of those who are dragging out time. Now that's all was done. Now you begin to say, should you call it quits? Should you say this is just too much to surmount? And believe me, at times I thought of that. But it always seemed to me we had a job to do, and that it wasn't finished until we got North and Poindexter's testimony. And about that time, we began to find that our document requests had not been honored by Secretary Weinberger and even in the State Department, and that we were getting documents that were disclosing new information, particularly about the 1985 arms transactions. And it began to become clear that the congressional committees had been lied to, that Weinberger had told them that he did not have notes. He sat as close to them as that chair is to me. And his desk is here with drawers full of notes. And he's sitting there saying that he didn't have any. Then he makes a note of of the interview and puts it in the drawer with his notes after everybody goes. Now, this we found out much later. Well, now, with that kind of information, you can't just walk away. You have to evaluate it, even though you know late prosecutions are hardly ever welcome and they're extremely difficult. And at the same time, the CIA activities were becoming more clear to us. Their cable traffic was very hard to decipher and to understand. And some of the associate counsel did an outstanding job of sifting it out and understanding it. And Fernandez, even after he had escaped prosecution because the CIA wouldn't release non-secret classified information, gave testimony that was helpful. And so it ended up in a plea of guilty by Fires, and when Fires cooperated, that again opened a new dimension. So even though the costs were running up, and we were maintaining these offices for the defense and offices for us, it never seemed to us that we could walk away from it. And so that's essentially the story of it. Now, we fully believe that the cases that we had pending at the end of last year, end of 1992 against Weinberger and Claridge should have been prosecuted. And there was no excuse for the pardon. But at that point, it seemed to us that the time had been reached to really give up, that in a sense the combined forces of congressional immunity on one side and presidential pardons on the other and classified information control on the third were almost becoming insurmountable at any degree of reasonable expense of time and money. So we concluded at that point. We considered whether the investigation should continue on any of President Bush's conduct, concluded it should not.
Judge Walsh?
I'll start with Nina, and I'll go to you, and then to you.
Judge Walsh, you paint a picture in the report of a broad cover-up. Do you think the pardon was part of the cover-up?
I had no proof that the pardon was conceived for that purpose. No proof that I could have used in any proper investigation or prosecution. No, I'm sorry.
Judge, do you think that the appeals courts that overturned both North and Poindexter's convictions injected politics into their interpretation of the immunity statutes?
No, I do not. I think that it's a very difficult question. And the Castigar case that set the guidelines for what could be done after immunity was granted needed to be filled out. And I think the majority of the court took a strong view that that protection should be extremely full, and they expressed that. It does mean that I think the views of some of those in the congressional committees that there was a possibility of concurrent activity that the Congress could investigate on television, and that the criminal prosecution could also go on, was just proved to be wrong. And I think the lesson is very clear, as we spell out in the report, that Congress has control. It's a political decision as to which is more important, but it can't have both. If it wants to proceed with a joint committee or a special committee, or to have to compel testimony by granting immunity, it has to realize that the odds are very strong that it's going to kill any resulting criminal prosecution.
If all the facts that are now known had been known in 1987, for example, do you think it would have been appropriate for Congress to consider impeachment, either of President Reagan or of Attorney General Meese?
The question is whether it should be considered. It certainly should have been considered. Whether it would ever reach that point, I think, is doubtful. But the fact is, Congress was deprived of that opportunity by the withholding of notes by Secretary Weinberger and by Secretary Schultz's assistant, Charles Hill. Those notes, I think, would have made Congress think. When you think of it, Congress didn't even call Vice President Bush or President Reagan. It didn't even ask for their depositions. It didn't even ask for interrogatory answers. It went off on the theory of a runaway conspiracy, which proved to be an unsound thesis. You and then out there, okay.
Mr. Walsh, I wonder how you feel that one of the principal outcomes of this whole laborious, difficult affair has been that Oliver North has become a millionaire and a candidate for the United States Senate.
You always ask a very penetrating question. I don't think that is a proper subject for my comment. I think that the investigation of Colonel North proceeded as vigorously as it could. The trial proceeded vigorously. The jury of plain ordinary people returned their verdicts of guilty on 3 felony counts. The Court of Appeals reversed it, and under the law, there is no barrier to his pursuing whatever career he may seek.
Yes, Judge, could you address, procedurally speaking, what the ramifications might be if Secretary Weinberger or anyone else who made false statements under 1001 in the past, if they were to do so in the future about the same set of facts?
In other words, if 5 years after the first misstatement, they repeat that misstatement.
Well, yes, but he's got the pardon. In other words, how does the pardon factor into this procedure?
I don't think the pardon protects him for future misstatements, so that if there should be a future misstatement.
Judge,
you sort of blame the more controversial parts of the report on the law, namely that you have to explain why you didn't prosecute. Do you think that section of the law should be repealed as Congress is considering, or do you think it's a good law?
I've thought about that. I haven't expressed any views on it. I don't know what other way there is to keep an independent counsel under some sort of supervision without destroying his independence. The idea is that independent counsel, in other words, the appointing court had no supervisory control of me and wasn't responsible in any way for my activities. But it somehow, it seems, even at the end, an independent counsel with that much power should have to account for what he did. And I think Congress is concerned that it wanted to be assured that not only were the convictions or the prosecutions justified, but also that the failure to prosecute was justified, particularly when you're bringing a lawyer in from private life. It's not as though we're doing this day in and day out, or I had a confirmation by the Senate and they'd had a chance to examine me. I was appointed outside of government, and there had to be. And I think the court in Morrison against Olson, the Supreme Court, was somewhat mollified by the fact that there was a reporting requirement. And so I don't know what the answer. I don't know any better system than one we have, which this court, the court that appointed me, has gone to great lengths to protect the individuals from any excesses of my report. On the other hand, as I said earlier, I couldn't sugarcoat the report just to encourage publication. I had to report to the court. At that point, it's a private report, and the court had to make its decision as to whether the public is best served, notwithstanding possible injustice to some of the individuals from some overstatement by me. We tried to write the report in as moderate a way as we could, but other opinions will differ on that, and they have made very clear that they don't quite agree.
Well, surely you didn't oppose publication of the report.
Oh, no. I hoped it would be published, but on the other hand, I was unwilling to alter the content of the report to encourage publication. It seemed to me my first duty is to the court, and secondly and hopefully to the public and to Congress. Yes, sir.
The report essentially says that they got away, the Reagan White House got away with a cover-up. Having been immersed in this for several years now, do you see any way to prevent future administrations from essentially doing the same thing?
Yeah, only thing, you know, it's a clumsy and expensive way to do it, but it's by having them prosecuted. I mean, that is the justification for the Independent Counsel Act, where the Attorney General, and I don't mean to, this is apart from any claim of misconduct, where any Attorney General is advising the President and feels a protective sense toward him. It's difficult for that person to turn around and be the prosecutorial officer. And that's the essence of the Independent Counsel Act. So I don't, you know, expensive and cumbersome though it is, and time-consuming though it is, I have not been able to think of a better system.
But the senior officials of the Reagan White House got away with what they tried to do. I mean, a few people ended up getting nabbed. They were the lower level officers.
The problem lay in the slow production of records, and that can happen in any kind of litigation. It is a problem found both in private life and in government life as you get closer to the top of an area of responsibility. That the person at the top is protected by his subordinates to an extent. And you have to work through that kind of barrier, and that takes time. And if it's complicated by withholding records, then it results sometimes in a non-complete accomplishment. Yes, sir.
Judge Walsh, one section of your report, which you referred to as a brief section, referred directly to the special division, is still sealed, is still classified. Can you tell us what generically that section of the report contains, why it still remains to be classified, and do, in fact, Clinton administration officials still believe that information is classified? And lastly, is it your view that in order to maintain the independence of the independent counsel, there needs to be a process that removes from the agencies involved in these investigations the final declassification authority?
Okay, I take it step by step. The appendix is relatively thin, but it is an appendix of material that the interagency group felt was not ripe for declassification. The interagency group has been has really done outstanding service for us in trying to get quick answers for us on these questions of classification. And so I simply accept that determination, and these are career officers in both administrations. Come now to the next question. Even when the interagency group feels that something is classified and must continue to be, then you go to the discretionary level above that for declassification, particularly for litigation. And as we all know, that goes to the agency. Then they actually have an interagency group of high officials who consider it, and in the end the Attorney General makes a decision. He can overrule the decision of the intelligence agencies if he sees fit. Now the problem comes that the Attorney General knows his own cases, or can be informed of them, and he can make a judgment of the value, based on what the intelligence agency tell him, of the material that's going to be disclosed, the true nature of its secrecy, and its importance to the case that his department is trying. But when the Attorney General disqualifies himself because of a conflict of interest and retains that power, that gives him the power to kill the prosecution of an independent counsel. frequently when he doesn't know the full significance. And in our case, we were quite disturbed that we weren't even talked to. In other words, we were not given an opportunity to present our views to this interagency meeting of high-level people or to the Attorney General himself on the Fernandez matter. He concluded that it was not a worthwhile prosecution. I think the response of Fernandez has the paper he filed appended to it in volume 3 now of the report.
What is the solution? Does it require...
The solution, it seemed to us, was not to give the independent counsel the power that the Attorney General has, because a transient, I don't think, should be entrusted with the power to declassify documents. But there should be a group in which the independent counsel is either a part or has an opportunity to make his presentation. I wrote President Bush saying that we were going to get into this box, and his counsel wrote back that that wasn't a presidential problem. He's quite content to have it go the way it was going to go. But I do think that there should be some kind of a reviewing agency other than the disqualified Attorney General. And the second thing is there should be some kind of written standards. Now they're not always a very perfect solution to things, but at least have some kind of standard set out so we know when classified information is critical to national security. If it's already exposed and everybody in Nicaragua and the United States know the information, why must that be held classified just to preserve deniability? There ought to be some articulated basis against which the particular incident can be measured. Yeah. Yes, sir.
Well, just a quick follow-up to that. Then, do you feel the Freedom of Information Act should be altered in any particular manner to accommodate that, and who should have authority over that in cases like these?
I think it would be inappropriate for me to talk about the Freedom of Information Act. I haven't really concentrated on it. I've been preoccupied with my own fields, and it seems to me if we can't even get the information for a government-conducted criminal prosecution, it's a much more difficult question to say that it should be dispersed publicly. But I haven't really thought about it. Yes, sir.
Judge Walsh, you say that Congress incorrectly characterizes the Iran-Contra affair as a rogue operation in the White House. No. What's the right way to characterize it?
The right way to characterize it is a willful pair of activities embraced by the President and carried out by persons who wanted to achieve his goals and found they could not do it without running a risk of violating the law. In other words, it wasn't they didn't run off by themselves to violate the law. They thought they were carrying out his wishes, and they had the backing of very high government officials in the agencies, in the State Department, the Defense Department, and the CIA. So it is in no sense a rogue operation.
Just a point of confusion here. On the one hand, you say that former President Bush is going to have to live with his pardon of Weinberger, that there was no public policy justification for it. But on the other hand, you say you have no proof that it was part of the cover-up. What do you think the purpose of the pardon was then?
It's one thing for me to say what I can prove in a criminal investigation and prosecution. It would be another thing for me to speculate on it. And I came pretty close to doing that a year ago, and I'm not sure I ought to repeat it now. I really think that this is the end and not the beginning, and I'll let the report speak for itself. Yes? Yeah.
In your conclusion, you say that President Reagan and others skirted the law.
Yes.
How close did President Reagan come to breaking the law, and how close did you come to indicting him?
The latter question is easier answered. We didn't come close to indicting him. How close he came to skirting it depends upon how you evaluate his activities under the circumstances of the time as we outlined them in our report, and in view of the testimony of Admiral Poindexter and Colonel North. Colonel North thought he had the President's approval for what he did. Poindexter said he never told the President about the diversion. He said that he felt that if he had told him, he would have been approved, which gives some indication of the climate of the situation, but that he wanted to preserve the President's deniability. And you take that as the center of your analysis, and then look at the circumstances around it, the repeated confrontations by the Iranian negotiators, the disappointments one after another, and you say, why? Why? And that's where it is.
Sir, just a follow-up. So what are you saying then? In other words, how close did the President come to breaking the law?
I have told you that as far as our proof is concerned, he didn't, and we didn't come close to proving that he did.
In your report, you say that you feel that the President, Ronald Reagan, knew about the diversion because he would not have accepted the affront.
We don't say that. That's what they say we say, but we don't quite say that.
What do you say?
We say that you have to analyze the facts in the light of that. That's a question that's raised in your mind, but not one to which we had an answer.
So you don't include that in your report? You simply raise it as a question?
No. Yes, sir.
Did you come close to indicting George Bush?
No. No. Yeah.
Well, she said that the activities were carried out by people who then found out that they couldn't carry out the President's wishes without violating the law. Yet Attorney General Meese defends himself by saying that, in fact, they believed that the Hawk shipment in 1985 wasn't illegal, and they never believed it was illegal, so there was no motive for a cover-up.
Then, yeah, go ahead.
Well, how do you respond to the legal issues, and what laws, if any, did the November Hawk shipment violate?
All I can say is that if you look at the notes of the November 24th, 1986 meeting, how is it that two people writing separate sets of notes, Donald Regan and Secretary Weinberger, both say that he said it might be illegal or it could be illegal? And then you have the notes of Secretary Schultz's debriefing that they are rearranging the record. So that's just starters. Okay. Okay. Yes. If I can. You've been trying for. I'm sorry if
you seem to draw a distinction in terms of the moral footing on which President Reagan stood and President Bush stood. I wondered what that was based upon, because throughout this report you get the clear message that this was directed, at least generally from the top. The President wanted the rebels supported body and soul. He wanted to trade arms for hostages. How can you in any way separate President Reagan from this policy and from this calamity?
The only thing you can't. But the difference is between a motive in a maybe erroneous view that this was in the public interest, and an act which in no way can be justified as an act in the public interest. It can only be either as an act of friendship or an act of self-protection.
How do you separate the moral culpability of a principal, the President Reagan in this case, and his deputy, political deputy, George Bush? How is Bush more culpable than his principal?
Well, I was talking about the pardon. In other words, the pardon is not justifiable, and he was no longer Reagan's deputy. Reagan didn't pardon anybody. Bush did.
Yeah, but that was his constitutional right.
His constitutional right, but his motive is a different question, and it's a perfectly constitutional right.
During the deposition here on page 473, we have Bush on 1/11/88 basically admitting that he was regularly informed of events connected with the Iran arms sales. That was at the very beginning of the '88 presidential campaign. Did you feel that you should have maybe broken that news a little earlier than today?
No, no. Actually, I didn't realize that we were breaking any news in the 1988 during the 1988 campaign. We tried to avoid that. Now, we obviously made a misjudgment in the second indictment of Weinberger, but that was not news. That was old information, but it was picked up as though it were new.
In the early months this is outside your jurisdiction, I realize, but in January of 1988, the hottest issue in the country was whether George Bush knew about the arms deal. And you have in your deposition here on 1/11 of that year that he admitted regularly being informed of events connected with it. Did you keep that information, or was that made public? I forget.
I don't think we were we were just releasing information because of campaign purposes at all, at any time. Yes, sir.
How close did you come to indicting Schultz, Meese, and Reagan?
I think the report states pretty clearly. It's a matter that, under the law, we had to consider, and it was a matter in which received very careful attention, but that's different from saying we came close. Good.
Just on another subject briefly, you said before that you wished you'd had a larger staff sooner. Do you wish, in retrospect, given the concerted cover-up that you faced, that you wished you'd hired more experienced, seasoned prosecutors to supervise some of the younger lawyers?
No, I wish, actually, we could have if you'll ask Mary, she'll give you a roster of our associate counsel. It's rather, I went over it just a few days ago. It's rather impressive. The number of former assistant U.S. attorneys and indeed U.S. attorneys who were on the staff. And particularly in the early period when these things were being done, there was most of the team leaders were former assistant U.S. attorneys, and then in the Poindexter trial, he was tried by a former U.S. attorney. So and even the younger lawyers had all been exposed to government activity. I would say 7/8 of them were former law clerks of judges. It was an extraordinarily fine group of people, and in some ways I wish I had put their histories in the report as well as their periods of service. But I don't think that was a problem that we had. And in the end, the follow-up investigation was conducted by Craig Gillen, who for 12 years had been in the U.S. Attorney's Office in Atlanta, first as an assistant U.S. attorney, then as a supervising assistant U.S. attorney, then at the head of the narcotics strike force. So, I mean, what are you going to do? He had 3 times as much experience as most people you're going to find available for this kind of work.
We had those people sooner, though, as in the case of Webb.
We had them at the very beginning. I'll start right off. The first 10 people that I took, let's see who was there. There was Bromwich from the U.S. Attorney's Office of New York. There was Zorno from the U.S. Attorney's Office of New York. There was Swartz from the U.S. Attorney's Office of New York. There was Audrey Strauss from the U.S. Attorney's Office of New York, who'd been the head of their frauds unit and head of their appellate unit. There was John Douglas, who was assistant U.S. attorney who had tried the spy case in Baltimore. So half of them right there are that, and if I had a moment to think, I might think of another one or two. So, but we did not lack for experienced prosecutors at any time. Yes, sir.
If I could push the impeachment question one step further, suppose that in 1987, knowing what you know now, you'd been a member of the United States Congress. Would you have wanted to push for impeachment? I think earlier you indicated it was not likely, and now I'm asking you what your personal view would have been if you'd been in that role.
I think my personal view would have been that the investigation should have gone more slowly, that it should have developed thoroughly the facts so that all alternatives could be considered, and certainly that President Reagan and Vice President Bush should have been questioned.
And if that had all happened and everything had been on the table that's on the table now, how would you have voted on the issue?
Well, I don't think I'm going to get into that kind of speculation because, one, I lack the political background for it, and I don't think that a discussion a criminal investigation and prosecution conducted by a lawyer should be drawn into a consideration of such an important political... impeachment is both a political and a legal question. And it requires a very broad judgment, and it's something that any Congress would be very hesitant to do, particularly when the President thought he was acting in the public interest.
Some pretty harsh criticisms of you through the years, and even they've gotten pretty personal. How have you reacted to them? Do you have anything you'd like to say now to respond to those critics?
When I started to work as a prosecutor way back more years ago than I like to think, but a long, long time ago, and one of the first things you learn is the standard rule of defense conduct. If the law is against you, this is a defense lawyer talking now. If the law is against you, try the case on the facts. If the facts are against you, try the case on the law. If both the law and the facts are against you, attack the prosecutor. It's a cardinal rule, and it always works. And it's always good. It's usually good when the prosecutor in the trial finds himself under that kind of personal attack, because he's going to have a jury. And believe it or not, juries are very intelligent people, by and large. They have a sense of who is fair and who isn't. And if you attack a fair prosecutor, in the end, you suffer by it. And I hope that as you look at the report, you'll conclude we were fair. First of all, that's the most important thing, that we were fair, and that you will then look at those who criticize us and the things they say about us in that light.
What is your total bill for the investigation?
I don't know. It's in Volume 2. There's a financial report that was improperly indexed, but we're correcting that right away. And adding in, as I remember, the GAO added in the costs of the FBI and other people who assisted us. And also, when they applied the rules of the executive branch, we had to retroactively pick up some other expense. $37 million comes in my mind. Now that's pretty close.
Judge Walsh, was it worth it? And if so, why?
Well, I think it is worth it. And why? For two reasons. One, I don't think it could have been done much cheaper. And second, I think it is extraordinarily important that people in high level of government, and particularly in the national security areas where they think the facts are not going to come out, that people in those areas realize they can be prosecuted, they can be convicted of felonies, and that even though the criminal procedures are time-consuming and somewhat clumsy, they work. Yeah.
Judge, Oliver North has said that the country has put the Iran-Contra scandal behind them and that he has no problem with now running for the Senate. Is there anything that's going to come out in this report that's going to give Oliver North a hard time, other than he doesn't know?
I really haven't analyzed it that way.
Could you reflect on what it's been to work on this case for the past 7 years personally, and what are your plans now?
Well, the person who was hit hardest was my wife, who's been sort of left alone for 6 or 7 years, and I don't think we would want to do that again. But I don't think that a lawyer really should not accept an assignment like this if he's asked to do so by a court. That's part of his duty. He's had the privilege of being a lawyer for a long time, and he's expected to do services from now and then for the court. So I think there's no question that I should have done it. I just wouldn't want to do it over. Go back to private practice at Crow and Dunlevy in Oklahoma City. Yeah.
Do you
feel that the public would be better served if the Attorney General were directly elected by the people?
No, I think that'd be terrible. I think one of the great values of our Constitution is the President does control the executive branch of government, and he, right or wrong, he in the end gets the criticism or the praise, and the check of Senate confirmation, I think, is quite adequate. And I speak carefully because I've worked in states where there has been an elected Attorney General. And in New York, for example, the Attorney General is elected, the state controller is elected. And I was the governor's counsel and had very good relations with them. We never had a cross word. But the governor or the president or the chief executive has a responsibility, and he should have the appointive power, it seems to me.
How do the people then have the power to make sure that the president, as you just experienced for 7 years, behaves himself?
Well, there are a number of checks. The oversight of Congress is probably the most important. And the other thing is that in Washington, I think we have, I mean, the press and the media are outstanding. I mean, I've worked in a number of communities at various times, but the aggressiveness, I think it's extremely hard to keep secrets in Washington, and if you can't keep secrets, sooner or later congressional oversight is going to be called for if there's anything wrong.
Not to be argumentative, but if Congress was so successful in doing that oversight function, then they wouldn't have needed to have you do your function.
Well, it goes to the, I don't think you're argumentative, I think you make a very good point. But the fact is Congress was not given the facts. And it was an unusually successful exercise in secrecy that those carrying out the President Bush's were able to achieve. The fact that Congress twice asked the President for information on Colonel Norris' activities and twice was lied to. Now, Congress has got a lot of things to deal with and to take on and challenge and can start conducting hearings about the activities of a president when it believes in good faith it's been told the truth that certain things it was worried about didn't happen.
Well, I guess I'm not clear why, since you've provided a very important function. In other words, without your efforts, these things would...
I'm not sure I understand.
I said you provided, as independent counsel, a very important function.
Right.
Now, I guess I'm not clear why you don't want the public to be able to directly elect someone to do your function.
Well, whether there should be someone separate from the Attorney General is a different question than whether the Attorney General should be elected. Okay, now whether there should be someone separate on a permanent basis, the trouble with that is that any agency that carries on over a long period of time with no refreshing tends to sooner or later drop back into a commonplace approach to things. Now maybe that's good, maybe it's bad, but that's the argument against it, and I think you have to evaluate that. You notice it in regulatory, I was counsel to a regulatory agency for a while, a very good one.
You can't say that about government in general, could you?
Yeah, that's true, but you begin to become friendly with the people you're regulating, and it becomes less and less a standoff adversarial process and more one of a sort of an accommodation. Thank you. Thank you very much.